Good day. So, in keeping with the stance for legal practitioners as superheroes, today we're going to be talking about legal aid. Legal aid in Zimbabwe, with reference with other jurisdictions as well. We're going to talk about how lawyers and how the legal profession provides aid for the less fortunate. Now, we're going to talk about the old system of legal aid that was there, and then the new system that is there now currently in Zimbabwe. We're also going to talk about the contingency fee system that is there as well, and lastly, comparison with the legal aid in South Africa. Now, as an introduction, legal aid refers to the system of providing legal services to persons who are unable to afford to pay for legal fees for such services. The right to legal aid is implied in the notion of the universally accepted fundamental rights of equality, so it stems from the right to a fair trial. A person cannot have a fair trial if they are not given legal aid. Let's say, for example, a person is in court with a businessman, and this person lives on $10 a month, and the business person has 5 lawyers of the best lawyers in the country at his disposal. There is really not a right to a fair trial therein. There is no right to equality before the law in such instances. So legal aid is there to ensure that there is a right to equality before the law. There is a right to a fair trial. It shows the proper administration of justice. Now, the system of legal aid is there in Zimbabwe in terms of the Legal Aid Act. We're going to analyze it, criticize it, and also applaud some provisions that are there. Now, legal aid is extending the law to the less fortunate. Now, as we start off, the old system of legal aid in Zimbabwe was categorized into the civil court legal aid and the criminal court legal aid. In terms of the civil court legal aid, when a person goes into the magistrate courts, the existence of a system was seen in assistance of indigent persons. Indigent means very poor people. The system was called the Prodor system, and then we have a person who wants to sue or defend was a pauper who could apply to court. And for them to get legal aid, they must satisfy that the person had a prima facie right or an action or defense, and the person had no sufficient means to pay for the court fees. Then they will be provided legal aid. However, the court was not obliged to order appointment of a lawyer, but could order service of pleadings for free of charge. Right? This was the system that was there. So a very poor person would produce evidence to create a rebuttable presumption that the matter asserted was true, and there will be provided legal aid. Now, in terms of the High Court, the system was called the informal pauperis system. A person must apply to the registrar, and the registrar, if he had assets that are less than the specified amount, then they would be deemed to have insufficient means and would qualify. Now, the registrar was required to nominate a legal practitioner. However, the practitioner was required to investigate the applicant's means. You see, the process was just automatic, just to provide to ensure the right to equality before the law. Now, under the Criminal Court Legal Aid, the Constitution did not confer legal aid for right of accused. Legal aid could be provided for in the instance of the court or upon the initiation by the Attorney General. Once a certificate was issued, the person in question becomes entitled to services of a legal practitioner. So this was the Criminal Court Legal Aid. You do not have a right. If you are detained, you could be detained and not have a right to a lawyer. This was the old system. The new system of legal aid that is there is in terms of Section 70 of the Constitution, which says that the accused has the right to be legally represented by the legal practitioner assigned by the state if substantial injustice would otherwise result. Now, this is a very big statement. Big and yet too general for my taste. But let's continue. Legal aid. A good change from the previous provisions of Section 18, which stated that every person who is charged with a criminal offense shall be permitted to defend himself. So this new system that is there is very different. It shows a change because the previous section said you could provide your own lawyer, but now the new system is saying that legal aid is there if substantial injustice would otherwise result. So it's a good change from the Section 18, which said provide your own lawyer. Now, legal aid is also provided for in terms of the Legal Aid Act, which is there, established, which establishes the Aid Directorate, whose function is to provide legal aid to eligible persons and to do all things necessary to promote the provision of legal aid. Now, law officers under the legal aid need not be registered legal practitioners. As we continue on, in order to get legal aid, there are two routes that you have to that are there to get legal aid. The first route being by application. You apply to the director, and for you to get legal aid you must certify the requirements being that you have insufficient funds to obtain the services, and that there are reasonable grounds for initiating the or whatever initiating the case that you want to initiate in court, and that there is need and would benefit from the legal aid services. So those are the requirements. And then on receipt of an application, the director is obliged to consider the application and to either grant or reject. So, and also the director is only going to grant where there is sufficient resources. So therein comes the limitation. We know states or the government is always perpetually insufficient in terms of resources. So it now becomes a limitation for legal aid in Zimbabwe. As we continue on, the act is vague of nature because it says that you should have insufficient fund. Now, how is you should have insufficient means? Now, how is how far-reaching does the insufficiency have to be for you to have legal aid? That is the question. Now, in terms of Section 11, subsection 2, it says it leaves it to the discretion of the director to establish whether or not to give legal services, the type of legal aid that is to be given. Should it just be legal advice? And then you have to find yourself a lawyer to court. Should it be only legal representation without legal advice? So it is up to the discretion of the director to establish all those things. So this is legal aid in Zimbabwe. It does not even tell the amount of time that the legal practitioner must spend with the client that has been given legal aid. Now, as we continue on, the second route is either by instigation of a judge or a magistrate or an attorney general. So when a client or someone gets into court and then a judge sees that this person has no legal practitioner, the presiding officer or judge or magistrate can then decide to initiate the proceedings so that the person can have legal aid. Now, they make a recommendation to the director, who either grants or refuses to grant that legal aid. It says here that in terms of Section 15 of the Act, a person who has been granted legal aid may be required to contribute to the costs to the extent to which, in the opinion of the director, is just and reasonable. So even if you are given legal aid, the director may say, there are these 2 court fees that you still have to pay. So in my view, it is very problematic now. There's 2 extra costs I have to pay, even though we both established that I have insufficient means. That is a point to ponder on. Now, as we continue on, if someone wants to come in and ask, is legal aid in Zimbabwe effective? And I remember in class when we were talking about this, I gave an example of the wind. The existence of something is usually seen by its effect. Your presence on earth is seen by the ripples that you leave behind through the people you have influenced. You cannot see the wind unless it moves a tree. You cannot see the existence of something unless you see the effects, the effectiveness of it. Now, can we really say legal aid in Zimbabwe is there or is in existence if it is not effective in its approach? That is what we are going to look at. So, the critical evaluation of legal aid scheme. 1. Legal Aid Directorate simply is a department in the Ministry of Justice. It is not an independent body. You get into court, you are represented by a member of the government, and yet you are fighting against another government department. Let's say you are accused of murder. The state is trying to prosecute you, yet another department of that state is the one that is representing you in your favor. Now, there becomes a problems there. So the lack of independence of the Legal Aid Directorate becomes problematic in its efficiency. And then the criteria for eligibility for legal aid is also problematic, because it says here that you have to have insufficient means, and like I noted before, how far sufficient from sufficient do you have to be, especially with the inflation rates and whatnot? Who has the right to come in and say you have insufficient funds or do not have insufficient funds? And it is a very difficult criteria to meet now, because you now have to establish how poor do I have to be. The extent of my poverty is determined objectively by another person who has not been in my shoes. Now, the availability of legal aid is also not effective, because it says that it is subject to the resources of the state, and we know every state under the sun is always insufficient in resources. No state can clearly determine, yes, we as a state have sufficient resources to meet all the needs. No state is ever like that. But it says here that we are subject to that, so it becomes a problem in terms of the effectiveness. And then we have access to legal aid is tricky, because there is really little public knowledge about it. Not a lot of people know that there is legal aid that is available for the poor. So if you are ignorant of its existence, it becomes a problem. And in legal aid in Zimbabwe, it does not also, lastly, legal aid in Zimbabwe does not clarify the amount of legal aid that you should get. Am I going to get just legal advice? Am I going to get access to that lawyer for how long? Are they just going to represent me in court? All those things should be evaluated. Now, another extension of legal aid is the provision of the contingency fee arrangement. This arrangement is an agreement entered into between a registered legal practitioner and his client, in terms of which no fee other than court fees are payable by the client for the legal practitioner services in connection with any legal proceedings, unless the proceedings result in a decision in the client's favor. Its existence should not be disclosed. So in terms of this contingency fee, they're saying that it is an agreement a client may enter into. Let's say the client is insufficient means, they may enter into an agreement with the practitioner, who then says, you pay me when we win this case, right? Because they would have seen that the odds are in your favor. And the last point there to note is that it is not admissible as evidence in court. It should not be disclosed in court that there is a contingency fee, because there are some instances wherein a client may be compelled to say, court, this allegation is so true that this client, that the legal professional that I am dealing with who is dealing with me in this case knows it as well. He even gave me a contingency fee arrangement because he knows that these allegations are true. We are not allowed to do that. You cannot disclose in court. Now, legal aid is not only given by the state, but there are various non-government organizations that are there in Zimbabwe that provide legal aid. Now, lastly, we have a comparison, that is their legal aid in South Africa. It is regulated by the Constitution. It imposes a duty on the state to provide legal aid if the same requirement comes, if substantial injustice would otherwise result. But now the difference is that in South African law, legal aid is provided at the time of the arrest to the trial of the accused. That is the provision. But however, there is no such obligation in terms of civil cases. So this is the legal aid in South Africa. There is the legal aid board that is there. The board is independent. There is also provision of legal aid by law schools in South Africa and so forth. So in summation, legal aid just ensures the right to a fair trial. It gives those who cannot afford the right to equal access to court, equality before the law. That is the legal profession. Thank you.